Welcome to this video about mediation in the armed forces. It's presented by ICMAF, the International Centre for Mediation in Armed Forces. Mediation is a process for dispute resolution, so I'll start by giving some examples of disputes, outlining different ways of resolving them, and addressing some consequences. Then I'll introduce mediation in general and say something about its advantages. After that, I'll focus on mediation in the military environment. Finally, I'll look at the implementation of a mediation system in the armed forces and the role that ICMAF plays. Disputes go under different names, for example, disagreements, quarrels, grievances, conflicts. There are many possible subjects of disputes, for example, over the meaning of a contract, about the terms of a divorce, between two team members in the workplace over who should do what, between family members about an inheritance, between neighbours about noise, about a bungled hospital operation, about an insurance claim after a fire, over an unpaid bill, and so on. From these examples, you can see that a dispute may be just between two parties, but can also involve several. And the parties may be individuals or organizations. Next point, there are different ways to resolve disputes. First, there are systems such as litigation and arbitration, in which each party presents their case to an outside party, such as a judge or other authority, who then decides the outcome, and the parties in conflict have to accept the decision. And then there are consensual systems, such as mediation and conciliation, in which the parties try to reach an agreement between themselves, an agreement that is not imposed by an outside party. Litigation focuses on interpretation of laws and jurisprudence. It tends to disadvantage the party with fewer resources. They may feel that's unfair. Usually the judge finds in favour of one party. The other party loses, so continues to feel aggrieved. Often the judge doesn't award the winner everything they asked for, so they also feel aggrieved. Litigation focuses on the past, what happened. It doesn't address the future relationship between the parties. That's unfortunate if they are going to be in close contact in the future. Typically, litigation doesn't address the emotional aspects of a dispute. Yet, as you may know from experience, these are important. Parties often find themselves thinking a lot about lines of attack and defense. Their blood pressure may go up. As disputes go on, consequences can become severe. Parties may suffer from anxiety, insomnia, inattention, irritability, and depression. These may spill over into their behaviour and family relationships and affect their workplace performance. Let's now look at mediation, a dispute resolution system that does address the emotional aspect of a dispute. Mediation is a process in which two or more parties in dispute attempt to reach a mutually satisfying agreement with the assistance of an independent, neutral third party, the mediator. Unlike a judge in a court or tribunal, the mediator isn't there to judge the rights and wrongs of the dispute. The role of the mediator is to assist the parties in getting to an agreed resolution of the dispute. Mediators are trained and experienced in using special techniques, mediation techniques, to help the parties in the dispute resolve their differences and agree on the way forward. The mediation process usually includes several meetings between the mediator and the parties. Some of these may be between the mediator and each individual party, others between the mediator and both parties. Mediation is a very different approach to, for example, litigation, in which lawyers act for the parties, a jury or assessors make their decisions, and a judge makes the judgment. In mediation, the parties find the solutions and agree the decisions themselves. Mediation has many advantages. One of these is speed. Often, assisted by the mediator, the parties will get to a solution in less than 1 day. That's much faster than litigation, which could take years, waiting for documents, waiting for preparation of legal arguments, waiting for a time slot at a tribunal or court, waiting for the judgment, then waiting again if one of the parties decides to appeal. Fast resolution of a dispute is important because the strain on personal emotions builds up when the dispute isn't resolved quickly. For the parties, it can lead, for example, to substance abuse, and it can have a severe effect on their family and friends and on workplace performance. Another advantage of mediation is lower cost. The cost of a mediator for a day is much less than that of an approach such as litigation, which involves many people such as lawyers, judges, assessors, witnesses, experts, and court clerks over a long period of time. Another advantage, mediation goes deeper into the dispute, so is more effective. Superficially, it may seem as if mediation just leads to an agreement, but importantly, it does this by getting the parties face to face to address the causes of the dispute. It doesn't just address its effects. Another advantage, mediation builds trust. Mediation obliges the parties to work together and trust each other to find a solution. That's a first step to restoring a relationship of trust between the parties, which is particularly important if, in future, they're going to be in close contact in family or workplace situations. The military environment has some special characteristics, such as a hierarchically structured organization and the chain of command. Members of the armed forces are in a high-risk, dangerous and stressful occupation. They live and work close together, perhaps in a barracks or on a ship. They may be called upon to serve and give their lives anywhere in the world. Loyalty, obedience, discipline and teamwork are fundamental values of the military organization. Notwithstanding these special characteristics, the mediation process in the armed forces is basically the same as that applied elsewhere. And many of the disputes in the military environment are similar to those elsewhere. For example, work assignments, organization of activities, working relationships, performance reviews, postings, training exercises, promotions, awards and decorations, and so on. Then there are those related to housing, family issues, vacations, sporting activities, personal relationships, and others about injuries, accidents, unacceptable behavior, pensions, and so on. Mediation solves disputes quickly and effectively, preventing them from festering and from leading to worsening relations between valuable, highly trained members of the armed forces, a fall in morale, and unhappiness with military life. The knock-on consequences of disputes, such as reduced performance at work and breakup of workplace relationships, may be severe in civilian life. In the military, they can be disastrous. Addressing the emotional part of a conflict, mediation restores the relationship of trust and rebuilds morale and the spirit of cohesion. Another benefit of mediation in the armed forces is that it doesn't have constraints on time or place. It doesn't, for example, have to take place in a particular building, such as a court. It can take place anywhere, even overseas. Another benefit is confidentiality. Everything said between the mediator and the parties remains confidential. Details of the dispute and its resolution won't be published. Another important benefit is that mediation is a low-cost dispute resolution option. With armed forces budgets under pressure, it's a good way to keep costs down. With mediation providing so many benefits, armed forces in many countries are looking to set up or improve their mediation service. But many questions arise when implementing a mediation service in the armed forces. They can be grouped under several main headings. For example, how do we get started? That could include questions such as who takes the first steps, who has to approve them. Then there's what do we need to do? That could include questions such as what's the action plan? What are the main procedures, roles and responsibilities? What types of dispute should be addressed with mediation? Should mediation just be for active personnel or also for reservists and for civilians under contract to the armed forces? And which ranks are in the scope of mediation? Then there's another important question. Why do we want to do this? It's likely there'll be some opposition to introducing mediation, so it's important to know how to overcome fears and resistance to change. And then, who will be involved? How many mediators will be needed? Who should they be? And who else should be included in the mediation service? And once the mediation service is in place, there will be questions like what should be done to maintain it? What should be done to improve it? ICMAF can help answer all those questions and many others. ICMAF exists to assist with the implementation of mediation in the armed forces and to help improve existing mediation services. It trains those involved in the mediation service and informs about mediation systems already in place. That's the end of this video. Thank you for watching. For more information, please visit the ICMAF website at this address.